And I'd like to introduce Bill Mavity, who's an experienced trial and appellate lawyer. He has argued in one cases involving issues of constitutional law before the Minnesota Court of Appeals, the Minnesota Supreme Court, and the U.S. Court of Appeals for the 8th Circuit. He is retired now and lives in Pepin County, Wisconsin, where he has served on the county board for 3 years. And he is currently chair of the Lake Pepin Partners in Preservation, and this group was instrumental in drafting and getting passed an ordinance, an overlay ordinance that restricts all frac sand operations in the Great River Road corridor. And I'm sure we'll learn more about that. Thank you, Bill.
Thank you.
Do you want me to close the door?
Let me just repeat what I said about the handout. The handout has a list of cases, court cases, for both Minnesota and Wisconsin that address all of the constitutional issues that can be raised to challenge an ordinance that would ban or restrict frac sand mining. I'm not going to go through all of those. I'm going to highlight some of the key principles. But it's important for you to take that back home with you, to share it with your group. It's easy now to find cases. You just take the case site in there and Google it, and the whole case will come up. You don't need a legal research program anymore to find out what the law is. Understanding it is another thing. But let me start by saying this. Whenever, both in Wisconsin and Minnesota, whenever a frac sand developer learns about an effort that a local unit of government is making to pass an ordinance to restrict in any way frac sand mining, they really come on the offensive. They come to the board meetings. They sometimes verbally attack the folks in a very big way. I attended a hearing in Buffalo County last fall of the zoning committee, and the members were almost physically attacked. It was very ugly. But the issues that they raise is that you can't pass these ordinances because they either involve the illegal taking in violation of the Fifth Amendment to the U.S. Constitution, taking of our property, or they deny us a due process of the laws, or they are a violation of our rights to equal protection under the law. The first 6 or 7 pages in your handout take each of those primary principles, takings, due process, and equal protection, and spell out the principles that are in play there. An illegal taking of property challenge cannot work in either state unless the challenger can prove that the ordinance has taken all of the economically beneficial value and use out of that property. And one of the sites in the cases that I have in the handout, I think the U.S. Supreme Court has said this: we're not going to sustain the challenge because we're taking away the right of the property owner to make more money. In other words, in order to challenge an ordinance on that it's an illegal taking, the challenger has to show that there's just absolutely going to be no value left in that land. Where you take away, or where you're regulating an area that has farmland or even business properties that are successful and that sort of thing, the taking thing is not going to succeed. Another way that they try to challenge it is through the claim that they've been denied due process. There's 2 types of due process. And again, this is laid out in the cases. One is procedural due process, and that's the one that they normally would bring if there was a problem there. Procedural due process requires that an ordinance be based partly on the information from a public hearing or from other sources where people have a right to be heard on the ordinance. Due process is a town or county giving notice as to what they're going to pass and a right for people to be heard. I think with the statutes that are in place in both states, rarely is there going to be a due process problem in passing an ordinance. The equal protection issue is very interesting. The Hanford case, which is the case that's in the last case that I talked about in the legal materials, is a case in California where a town distinguished one type of home retail store from another type of home retail store, a large one versus a small one. And the ordinance permitted the large one to operate, but not the small one in a certain district they had. And of course, it was challenged by the smaller one, saying that you're singling us out and treating somebody that's similarly situated more favorably. That's a denial of our rights to equal protection. And while the California Supreme Court law is not a precedent for Minnesota, Wisconsin, the reasoning is well rooted in U.S. constitutional law that even with regard to an equal protection challenge involving similarly situated parties, where the ordinance treats one more favorably or more harshly than another, that can be defended if that ordinance has a legitimate or rational reason for that, having made that different classification. And then finally, the most important principle, I think legal principle, that we have to defend ordinances is that in the context of constitutional law, the way that the courts analyze whether a regulation or rule is going to be sustained is whether there's different types of scrutiny. And the area that I was most familiar with was strict scrutiny and intermediate scrutiny, because I practiced the area of discrimination, employment discrimination. And with race, whether it's a right to vote or a rule that affects racial minorities differently, the court looks at that with strict scrutiny. Is there a compelling government reason to make that distinction, treat that person differently? With gender, it's an intermediate level of scrutiny. It's not such a hard burden for the rule maker or the ordinance passer to pass. The other level of scrutiny is rational basis. That's the rule that is applied when courts look at ordinances, economic regulation. That rule is that if the court finds any rational basis of any kind in your ordinance for the finding, the description of what it's trying to regulate, then the courts are going to defer to the judgment of the local body passing an ordinance, even if they don't agree with it. That's the law in the whole country. In Wisconsin, it's the Ryan versus Beazle case. The courts have said, we're not even going to consider overturning an ordinance regulating land use unless the challenger can prove that it's not rational beyond a reasonable doubt. That's the same standard you have in a criminal case, which means courts will defer to your ordinance, even if it's banning a land use like frac sand operation, if you've got a rational basis in your ordinance or in your public record supporting it.
I just had a quick question. Does that include even if your township is not zoned?
It includes any ordinance that's passed. That's right. I'm not going to spend any more time on the legal stuff, and I want to save the questions until the end, because I also want to touch a little bit on federal preemption as it relates to railroad use that might implicate frac sand, transloading, that kind of thing. I just want to touch on that a little bit because, contrary to what railroads tell you, federal preemption is not without lots of exceptions for local units to use to support to get an ordinance or a permit or a condition in a permit approved. So what I want to do today is to give you the tools, and a lot of you already know these. Amy and Keith talked a lot about the way they've gone about getting their ordinances passed. I want to talk to you about the fact that the law is on your side, We've got to educate town board attorneys and county board attorneys about that because they don't deal in the area of constitutional law. They're dealing in areas that they do the same thing all the time. It may be a part-time attorney with a civil practice. He's involved in real estate transactions. If he's a county attorney, he's prosecuting misdemeanors, having child custody. Once you let them know, and if you can get them to read the cases, they will find that whether it's the rational basis or the illegal takings principle, it is the most favorable law they will ever find for anything they do. It is easy to defend an ordinance that's put together properly. That's the first thing we're going to go to when I get to the examples. The second thing was really, I thought, said so well by the Dominican sister. And that is, it is your duty to protect the things in your community that your comprehensive plans talk about from the noise, the dirtiness, the danger, and the ugliness of frac sand. What you have in your comprehensive plans, unless you're a larger city like Menominee where you have an industrial park, you've got policies and principles and goals that basically say we want to protect the quiet, the beautiful, the clean, and the safe in our community. And that's not frac sand. Okay, let's look at the examples. You're going to have to refer to your handout for the rest of the lecture here. The first thing I included was Article 1A of the Town of Stockholm frac sand operation.
Are there more handouts? Okay,
They're out.
sure.
Is it just one person that needs one? Okay, I have one, I think, extra. But here's one.
Okay, I have.
Let me just quickly tell you about what we did in Pepin County. And I got my energy and my motivation for getting involved in it from Keith Boston primarily. I attended that first library meeting and heard about what was going on. I'm a retired lawyer doing things like gardening and I had a friend in town at the time, a good friend of mine, a lawyer from Chicago. And let's go check this out. So we drove over to the 155 acres at 2.5 million. Windsor Permian, now called Muskie, a subsidiary of Wexford Capital, private equity firm. So we looked at that, and everybody that's there can see how beautiful it is. We got some information about a Hanson Harbor involvement. So we went over and talked to that guy. Didn't tell him we were lawyers, but we found out a lot about the reach of Muskie, the Wexford Capital, around that area. We drove over to the next day. We went, of course, I knew Maiden Rock and what was going on down there. We drove up to Twix Valley in the town of Auburn and kind of got lost, so called Pat Papa, who I didn't know. I called on my phone information first, do you have a number for Pat Papa? And they did. And I said, tell us where to go. I don't know if you remember that. Or you've had many calls like that. So we drove back.
I remember meeting you though.
This is 2011, and I'll tell you, the town of Auburn looked bad then. And I've been up since then. I mean, it's just a disaster. So,
we're from the town of Auburn.
so you had to do something about that. And so just to shorten up that part of the story, decided our county board supervisor became ill, left the board. This was and then in the summer of 2011, I was appointed to fill his position and then was elected for a 2-year term in 2012. In November, I authored a moratorium ordinance. There weren't any in Wisconsin that had been passed yet, and it was opposed by our zoning administrator, by our corporate counsel, Riley, Prin, Weld, and Ricci. I don't even like to remember their name. That attorney came to the board meeting and argued against me, one lawyer to another. Fortunately, moratorium passed. He said moratoriums are illegal. Chippewa County saw our ordinance and you folks passed your moratorium about 6 weeks later, I think it was. It went in very quickly. That particular law firm, of course, was representing a lot of frac sand clients at the time. It wasn't really an issue of law. In February of 2012, we had a court decision upholding a licensing ordinance that tightly regulated frac sand. That was Tooks Valley. And the court, Justice Abramson, Chief Justice, went through the whole zoning licensing issue and made it clear in there, in language, that you can ban frac sand mining. They called it something different then. They called it non-metallic mining. But that inspired our two town boards in the area where I live, the town of Stockholm and the town of Pepin, to pass licensing ordinances. We had a lot of people get very involved all of a sudden because Musty, Windsor Permian, Musty, came over and proposed to build, and have a big design, a transloading, processing, and they also want some probably where they could mine right across from Lake City. It's right just between the Fort St. Antoine site, if you're on that side of the river, and JJ, which is in the town of Stockholm. It would have generated about 1,000 trucks per day. It would have had night lighting. It would have destroyed sailing in Lake Pepin. And of course, the noise comes across the river. Lake City shoreline would have been a disaster if that had passed. That motivated people to get together. So the licensing ordinances were passed by the two town boards, banning in their townships all processing and all rail loading. Those two townships covered the entire shoreline of Lake Pepin in Pepin County, which is most of the lake, all the way down to the Chippewa River, from Maiden Rock to the Chippewa River. In 2013, another county board supervisor and myself sponsored a overlay zoning district that would ban all frac sand operations of any kind along the Great River Road corridor. And how we did it was interesting. The group of citizens that had been motivated to stop Muskie got together and formed a 501c4 corporation, a social welfare corporation. It's like a super PAC. You can raise money. You don't have any tax exempt. People that donate don't get an exemption. But you can legislate, you can lobby, you can do these kind of things. We had Paul Kent do a general draft of he's an attorney from Madison, Wisconsin, do a general draft of an overlay district, and then that group went to work. And they wrote, these are property owners, business owners, Republicans, Democrats, myself as a lawyer, one judge from Hennepin County. We put together a overlay zoning ordinance that would ban all frac sand operations, and we tied it together with the two town board ordinances. A little bit later on last year, the town board of Stockholm passed a frac sand ban itself. They zoned it, and that's the one I want to talk about first. If you're going to take advantage of the law, the rational basis that you need to successfully defend an ordinance, you have to have findings and you have to have some support for those findings. In subdivision 1 of the first page of that ordinance, the town board lists all of the harms that are caused by frac sand mining. We all know what they are. Included in there was a description of a harm that's caused by too many trucks on the highway. Too many trucks on the highway drives away tourists, which hurts your area if it's a tourism and recreation economy. It affects the tax base by reducing the property value. If people don't want to buy land, even on a bluff that's got a beautiful view of the lake, if you've got the noise and vibration below you. And two things that are important for you to note. At the very bottom of page 1, the last sentence, it says, without town regulation of frac sand operations, serious and irreparable harm to the health, safety, and general welfare of The town, its citizens, its environment, air, water quality, and its economy are substantially certain to happen. In the next page, the next line, the bases for these findings include numerous relevant economic and health-related studies of the potentially harmful effects of frac sand operations. And in the public record, it lists most of the things that Amy's put on their website. It lists some other studies, our own economic study. If you have findings and you have a public record where somewhere in a similarly situated area, you've had a frac sand operation that's been studied, and it causes congestion, it causes very ambient air particles, it can cause cancer. It is not consistent with the comprehensive plan. The submission of a comprehensive plan for an affected community should be part of the public record in passing that ordinance. If you've got that, the court is going to look at that ordinance and say, they've got a rational basis, which is a debatable point, that's all it needs to be, for that particular set of findings. So we have to accept them, we have to defer to that judgment. The other thing you want to do in the ordinance, on page 3, the pages on the bottom, you want to have a definition that really tells the court what you're trying to regulate. And early on, we figured out that what we should be defining as the activity we're trying to regulate is not non-metallic mining. We're trying to regulate frac sand operations. It's an enterprise. They're classified differently by the federal government. The difference between gravel and aggregate mining for construction purposes and frac sand mining. Frac sand mining is different in terms of the size and tonnage that are mined, different at the site. It's different in terms of the way that it's processed. The chemicals are used. It requires an enormous amount of water. In fact, in Wisconsin, a processing site that is not on a mine site is not even classified as non-metallic mining. And of course, the transport and loading of that. This together is a classification that stands out by itself. At least in Pepin County, there's no other business like that in terms of the number of trucks that will generate, the amount of activity it is. So we defined the area, what we're trying to regulate in all of our ordinances, the towns and the county ordinance as frac sand operations. And those definitions are on page 3. And they're pretty clear. And at the end of page 3, we do say that the term frac sand operations as used in this article does not apply to the extraction, mining of the non-metallic minerals that are used for construction purposes. So that's the distinction. You see some ordinances where they say this is an ordinance regulating non-metallic mining, but it does not include, and then you've got 3 pages of things that are not included, which is confusing to the court, among the other things.
Bill, would it be correct to say you're defining frac sand by end use? Because that's a
Yeah, that would be that's the bottom line definition.
okay.
It is not a product that is used anywhere in Wisconsin. It can only be used for the exploration, drilling of oil from shale beds.
And you think that's a viable definition, defining it by end use?
Well, it's more than just end use. It's the whole enterprise of getting it to the end use. It's together because these things are connected physically. You know, you're moving that sand from the mine to the processing, to the transport, and all along the way, that sand has an adverse negative effect, an adverse effect on wherever it goes. It's noisy, dirty, dangerous, everywhere.
But if you weren't using it for hydraulic fracking,
I think you could still make that classification because it's so much different in size. Let's say that you had a frac sand mine within 50 miles in your county of hydraulic fracturing. You could still regulate it. Its end use is in the county. It's not for building highways, it's for drilling oil, but it's still different. It's different in terms of its basic characteristics. And the Supreme Court, particularly U.S. Supreme Court, principles in terms of equal protection, and that's the Hanford case at the end of this, you can distinguish between similarly situated businesses or land uses if you've got a basis to show that one is really different in terms of its impact. So maybe it's not just the end product, but it's the impact that really, I think, probably matters most. Go to the chart. This is another way, a critical tool on how you build a rational basis. We had identified at the Pepin County level the studies, or at least at our 501c4, Lake Pepin Partners Preservation. We had identified the studies that we knew would make the connection. It doesn't have to be a conclusionary connection, but it has to be a correlation of some kind between bad things happening because of frac sand operation. So when we had our zoning committee public hearing, we put together what I call a scorecard. We had everybody sign in. The first top 4 signatures there are, they're not signatures, the village of Pepin, the village of Stockholm, the town, 2 towns. What we had there were resolutions of support from each of these communities. Now, our 501c4 corporation had elected officials from each of the 2 towns and the 2 villages, as well as county board members on that. As elected officials, they had to worry about the conflict of interest, so they were ex officio members, but they participated. We had property owners, ordinary residents, retired or whatever, elected officials meeting together. Each of these communities, Pepin, Stockholm, Pepin, and the 2 towns, are more conservative than liberal. We are a more liberal area of this region than many places, but they didn't have any problem once they understood that the harms that would occur here from putting those resolutions. This is a list of all the people spoke, and if you look down about halfway through the first page, Jane Whiteside submits a comprehensive plan. We had other comprehensive plans submitted as part of our public record. Towards the end, there's a couple of places where that happened, but towards the end, Steve Graham, Tom Pepin, he actually submitted, I think there are 5 different reports. As part of his testimony, some of the, I think 2 or 3 of these came right off your website, and you got those, probably to Amy. This is part of the public record then. And the reason why having a public record like this, a recorded hearing, the scorecard of who came, the materials that were introduced, is that when your county attorney or your town attorney gets that challenge from the unsuccessful applicant, the first thing that attorney will submit to the court is an affidavit identifying all of the studies, the research that provide the rational basis for that ordinance. And the court doesn't really have to go any farther than that attorney's affidavit to say, gee, we're going to have to defer judgment on that. The law is very clear. Where you've got a rational basis, we can't sustain that challenge. The next 2 pages are copies from a couple of pages from our Pepin County overlay zoning ordinance. Again, we've got definitions in there, but 2 different definitions: truck trips, high impact industrial and commercial operation, and the final one, frac sand operation. The last one, bans all frac sand operations in that Great River Road corridor. It overlaps the towns in that regard. Everything is banned there. In the towns, the 2 towns, they ban processing plants and rail loading where they border the railroad, but they allow 2 mines in each of the towns, a maximum of 2 mines. Stockholm is zoned agricultural, and they use a concept called a floating zone, which is not the spot zoning that's illegal. The floating zone allows 2 applicants to have a mine no larger than 20 acres But he's got to identify where it's gonna be. If the board thinks it's appropriate, we float a little zone down over that 20-acre area. We don't define a new district that's open to the market. It's just that one mine. It's an effective way to do it. It's a $25,000 application fee. And that person knows there's no processing plant within a long ways away. How do you get it to rail? Can't get it to this railroad, BNSF in Putnam County. We kind of did what Keith was describing, is being rational, but making it very, very difficult, make it very difficult in terms of being economically viable to put down a line in that particular area. But it's still based on what the town is trying to protect. Going back to the 2 pages from the ordinance here, one of the things the ordinance does is this is on the first, it's on page 4, under use restrictions. Permitted uses and conditional uses are all uses that are already authorized by the towns and villages. Now, the town of Stockholm, in their town ordinance, prohibits trucks from using County Road J and County Road JJ. And those are the roads that go down into the tourism area. So even if you have 2 mines up there, you know, how can they ban traffic, truck-sand traffic on County Road J and JJ? Because they are linking with the county that says that the uses, well, it's in the special prohibition, but the uses have to be as restrictive as any in the towns. In the towns where the towns prohibit the use of county roads, we buy into that. We'll support that. In other words, if you want to sue the town for trying to regulate county roads, you've got to sue us too. We've already approved that in our ordinance. So we link in the town and the county ordinances, giving more protection to all. In the definitions, high impact and frac sand, we ban frac sand, we ban high impact. Frac sand is the toughest to defend because it's distinguishing frac sand, singling it out differently from aggregate gravel. I don't think that's tough, but the insurance lawyer for the county thought that would be pretty tough to defend. But the second one, we're also banning high-packed industrial and commercial operations in that Great River Road, and we define that back in the definitions with regard to any business that would generate more than 50 trucks per day that have a gross vehicle rating of over 50,000 pounds, or actually carry that over 50,000 pounds. But we're not distinguishing between types of land uses, we're distinguishing between the types of businesses that would be located in those land uses, which is an appropriate way. You can regulate activities as well. Buffalo County, in their ordinance, established some prohibitions on businesses that generate a certain amount of traffic. They got a letter from the General Counsel of DOT saying, you can't regulate traffic on Highway 35. The implication was that, you know, the road, the trucks would be driving on 35. Well, it's true, they would be. That's what they were really trying to prevent. But banning the land use that would generate that traffic is not regulating traffic. Buffalo County got another letter from a lawyer representing a large construction company that said that you are denying trucks the equal protection of the law, but considering them not different from persons, I mean from cars. That's not what the U.S. Constitution is trying to protect. So you're not, I mean, the point I want to make is that when you identify pretty easily the harms, the adverse impacts, and you get the information that you need that correlates with those harms, causing those harms, you put it in an ordinance, you build a public record of that rational approach to it, and you involve the kind of people that will make an impact with your county board. When this thing came to the county board for final approval, I didn't have all the votes. But I had elected officials from all the towns and villages testify. I had property owners. I had people that were known to be conservatives as well as liberals. They all testified in support of it. And one of the persons that was most opposed to it early on, said, how can we say no to all these people when it's going to affect them? That's a hard thing to get in lots of areas, but that's the clincher if you can get that. Let me just quickly say one thing. Federal preemption. The Interstate Commerce Clause Termination Act of 1995 established the Surface Transportation Board and gave them the authority to protect railroads from any local or state ordinances that would have an impact on the integral operations of railroads. What they don't tell you, the railroads, is that there are all, I'll give you just two cases, I'm not going to read the cases, I don't have time. The Emerson, actually, I think, well, the Emerson versus Kansas City case, the site is 503F.3D, that's third edition, 1126. That basically says that if the railroad does any construction that's going to affect the wetlands, the locals have a right to request an application for a permit.
Title of the case, please.
Sorry?
Title of the decision.
Emerson, it's a federal court case, Emerson versus Kansas City.
Emerson.
And the case that was cited to the village of Stockholm 5 months ago when they said to BNSF, this is the case that controls. The village of Stockholm asked BNSF to submit an application for permit to build a crossover between the two main tracks that was going to be in the town, and it was going to impact 0.47 acres of wetland in the right-of-way. But it still is in the right-of-way. I mean, it still is wetland, so the village has a right to do it. So we got a lot of attention from BNSF when we said we were going to file a lawsuit saying that they had to submit a permit. We got action from a guy named Tony LaRocca, Railroad Lawyer of the Year, saying you can't do it. Here's the Sioux Line case. The Sioux Line case makes clear on a couple things. One, local authorities, local townships and villages can exercise police powers if they think there's a threat there that will impact their citizens. And they also can regulate if it's an environmental issue. Friday, we settled with BNSF. The crossover is still going to be there, which we would like to have it moved, but we couldn't get it moved. But in terms of, without them conceding anything about federal preemption, they are providing about $526,000 worth of benefits to the village, including a constant warning time signal, so we'll have the quiet zone. They gave us a cost on that last year of $223,000, $250,000 in cash, plus they're going to build another extra access road between the right-of-way and our businesses on 35. That tells you that all the stuff you hear from frac sand developers and the railroad about the preeminence of their legal position, federal preemption, illegal takings, violation of our rights to equal protection, it's not that clear. The local folks have more authority than they know. And it is enough authority to sustain any ordinance that would ban or restrict frac sand operations if you go about putting that ordinance together the right way. I'm out of time. I'm going to be around. You can ask questions now or